Good morning, everyone, and again, thanks for joining us for our latest webinar on diversity and inclusion. If we could just go over to the next slide, please, Tom. So today, as I say, we're looking at diversity and inclusion, what's changed recently and what's coming up on the horizon. We've got some changes to legislation and a couple of cases that we'll be taking you through as well. On to the next slide, please. So the first point that we're going to be looking at is the prevention of sexual harassment in the workplace. And I'm sure, as you all know, this law came in place into force in October last year. So quite recent, but I'm sure you've all been busy preparing for this. As you may know, we did a recent survey, an employer survey, which hopefully lots of you responded to. And the results of the survey, as you can see there, were that 40% of respondents said that they had a risk assessment in place in terms of preventing sexual harassment, and they also had training for managers in place. 34% said that they had a risk assessment in development, so not quite ready, and they also had training for employees in development too. And then finally, for 26%, unfortunately, they weren't quite up to speed as yet. They said they weren't prepared. They don't yet have a standalone sexual harassment policy in place, haven't put in place training for managers or employees, and don't have any anonymous reporting system in place. So unfortunately, a fair bit of work for those people still to do. But as you all know, this isn't an automatic liability that says if you haven't put these steps in place by last October that you're going to have some liability. That would only come into play if you do receive a claim for sexual harassment from one of your employees. And if you failed to take these reasonable steps, unfortunately, any compensation that they can be awarded can be increased by up to 25%. That's the position that we're in now. And as I say, the sort of minimum things that you should be thinking about, if you haven't already, is to carry out a risk assessment as to where the risks lie in your particular business in relation to sexual harassment, where it's likely to take place, and what you think you can do about that. Of course, having in place a policy and communicating that policy even more importantly, so that people know what to do and where to go if they experience or see an incident. And of course, very importantly, training both for managers at their level so that they know how to deal with these situations, and for all employees as well, so that they know what's expected of them and other people and what to do if they see anything going wrong. And in terms of sort of further guidance, at the moment we have the Equality and Human Rights Commission guidance, which just explains a little bit more as to the type of reasonable adjustments that you can be making. And just over to the next slide, please. So that was the current position, and that was the law already in place now. But there are potentially going to be some changes which are coming into force through the Employment Rights Bill. Again, the Employment Rights Bill is probably something that you've heard about it. There's been lots of talk about it on the media. And this is a bill that's going through Parliament at the moment. And if it does come in, which is likely, will make lots of changes to many areas of employment law, which we won't be going through all of them today. So as I say, it's going through the parliamentary process at the moment. It's subject to several consultations, which have gone through or going through at the moment. And the government had said that the majority of reforms won't take effect before 2026. So we do have still some time to get prepared. So the point that we'll be looking at today is in particular in relation to sexual harassment and the changes that are proposed under the bill. So there are three different developments that are proposed. First of all, as I said, at the moment, the duty is to take reasonable steps to prevent sexual harassment in the workplace. Under the bill, this is proposed to change to all reasonable steps. So of course, it looks like the burden on employers is going to get higher. And if there's anything that you can imagine that would help to prevent sexual harassment, if it's reasonable, then it's something that really you should be doing. So although, of course, this does seem to add an increased burden, again, on employers, it does also resolve a bit of an inconsistency. Currently, as you may know, you can have a statutory defence, so a complete defence to harassment claims, not just sexual harassment in the workplace, if the employer considers that they have taken all reasonable steps to prevent that harassment. it would then give them a complete defence to that claim, and they wouldn't have any liability. And so really, if the duty to prevent sexual harassment becomes a duty to take all reasonable steps, that really just bring those two things in line, and the statutory defence would work in the same way. Now, the second development, and this one I think a bit more welcome for employers, will be that they're planning to bring in some regulations to say what reasonable steps means, and what you should be doing. Hopefully, this will give us sort of more information on what employers must be doing, and what are more of the sort of nice to haves over and above that. So I think really a positive step if this does come in to give employers some further guidance. There is, though, a bit of a double-edged sword with that, in that there is, of course, a risk that if it's very specific as to what you need to do, that this could become a box-ticking exercise just to comply, which is obviously not something that we want to happen, and it could mean that your prevention steps become less effective. So I think that's really something to think about. And of course, we're not just trying to avoid claims here, but we're trying to prevent sexual harassment in the workplace, and make workplaces more pleasant to be in, and everything that goes with that. The third development, and one that's very important, is the liability for third-party harassment. So currently, as the law stands at the moment, you have a duty not only to prevent sexual harassment in relation to between your employees, but also you have a duty to prevent sexual harassment by third parties against your employees. So this could be your customers, clients, also suppliers, for example, or perhaps delegates at a conference. So currently you do have a duty to prevent sexual harassment by third parties, and this is something that you should be considering in relation to your risk assessment and what you're putting in place. However, currently there's no liability, so an employee can't bring a claim against the employer for third-party harassment currently. Now, this is due to change under the Employment Rights Bill, as and when it does come in, so that the company would be liable in those circumstances. Now, this isn't something new. It's been debated over several years, and in particular, when the Equality Act first came in, there was a provision in there for liability for third-party harassment. Under that provision, it was going to be a sort of 3 strikes and you're out principle. So if you had had warnings that there was sexual harassment had taken place in relation to third parties against your employees, and you did nothing about it, and then it happened for a third time, at that point, the company would have become liable. Now, under the Employment Rights Bill, that's not what they're proposing to set out. Under the bill, the employer would be liable for third-party harassment if it's carried out in the employee's course of employment, so in the workplace, or potentially outside of work at work-related events. And if the employer failed to have taken reasonable steps to prevent that sexual harassment, they would then be liable, and it could potentially be just on one instance. So, as I say, this would be a really big change for employers. It's quite a burden on employers, of course. And the question is, what are the reasonable steps that you could take to prevent sexual harassment by third parties, given that you really have very little control over what they're doing? Of course, you can't give training to your customers or clients on sexual harassment, or delegates to a conference. That's just, it's just not reasonable. But what can you do in terms of steps to take? First of all, you can be placing notices in the workplace in relation to expectations around behaviour and how you expect your staff to be treated. And as I say, this could be a sort of physical notice. Who knows where it's going to be, sort of in a reception area and on the back of the toilet door, for example. Or it could also be on a website, contracts, things like this as well. In terms of risk assessment, this should also consider third parties as well. When are third parties going to be around your staff? Are staff going to be on their own? Is alcohol involved? All of these type of risks, and then looking at how the risks can be reduced. Very importantly, you need to have your policy in place for preventing sexual harassment. And again, as I say, of course, it needs to be communicated to your employees and clear to them, as well as to where they can go And we would advise that this should cover third-party harassment as well, in terms of how they're going to let you know about that, how they're going to raise that. Ideally to have a way to raise those concerns anonymously as well. And also I think it's about the culture of the organisation and really letting staff know and encouraging them to come forward if they do see or experience anything, and allowing them to feel comfortable to do so and to not feel that they are, say, less important than your customers, clients, etc., and that they will be listened to. Another step that you can take is to provide training on sort of bystander intervention for staff, so that if they do, say, see something happening to somebody else, they know how they can sort of help that situation, help to diffuse the situation at the time. And as I said as well, in terms of notices, this could also, for example, in relation to an event, be a pre-event notice to the delegates that you would give to the sort of third-party organisation, so that, again, everybody knows in terms of their code of conduct what's expected of everybody, and what's absolutely not expected, and how that will be treated by the company. And the next slide, please. So next, I was just going to have a look at I think a useful case. It's not a sexual harassment case. It's about racial harassment. However, you'll see that it is very relevant to this discussion. So the case was Campbell and Sheffield Teaching North Hospital's NHS Foundation Trust. And the facts were that Mr. Campbell was an employee of the trust and also a trade union branch secretary. You also had Mr. Hammond, who was also an employee and a trade union member. The issue arose when Mr. Hammond wanted to leave the union, and then there was some sort of problem because he told them he wanted to leave, but I think his subscriptions were still getting taken from his salary. This ended in an argument between Mr. Campbell and Mr. Hammond about the sort of membership fees, and Mr. Hammond made a racist comment against Mr. Campbell in the workplace. Mr. Campbell then claimed racial harassment against the trust. Now, interestingly in this one, the trust actually wasn't liable for this claim, as it was held not to be in the course of Mr. Campbell's employment. This is a sort of side point to what we're talking about today, but it was decided that as this was a discussion between a trade union member and a trade union official purely about trade union business and not related to their employment, it was decided that it was outside of the course of employment and therefore the trust couldn't be liable in any event. However, for our purposes today, the point that I thought was useful to have a look at is that the Employment Appeal Tribunal also looked at whether the trust had taken all reasonable steps to prevent the racial harassment. In this case, they did find that they did take all reasonable steps. So I think it's just quite useful to look at the facts here and see what the Employment Appeal Tribunal found was enough to have given them a complete defence to the harassment claim. So what they had put in place was an induction session for employees on dignity at work, and that explained the trust's core values, which were called PROUD. There was then an annual performance assessment for each employee, and included within this was a consideration of the employee's compliance with the PROUD values. There were posters displayed about it in the workplace, and mandatory training was provided to employees every 3 years on diversity inclusion issues, and that had actually recently been completed by Mr. Hammond, the perpetrator, as part of a small group session. So you'll see that this just really gives a helpful sort of overview as to what the tribunal found to be enough when we're talking about all reasonable steps here in relation to a racial harassment claim. And then just on to the next slide, please. So the question, of course, is, given that at the moment you have to take reasonable steps, and if and when the bill comes in, you will have to take all reasonable steps, what else could we be doing other than, as we said, the training, policy, risk assessment, etc.? There are lots of other things that you can be doing. Now, one of the first things we'd suggest is carrying out a SAR survey. I think for a lot of employers, for the majority, they're going to look at their own records and see whether they've got any instances of sexual harassment, and maybe think, oh, nobody's told us about anything, we don't have a problem here. But of course, we know that people don't always want to come forward. And so perhaps the more brave employers might want to think about carrying out a staff survey to really ask people anonymously, you know, have you seen anything? Have you experienced anything? How was it dealt with? How did you feel about how it was dealt with? And what could we be doing better? In their opinion, I think that would be really helpful to find out really what's happening on the ground. Next would be putting in place sexual harassment champions or guardians, so individual or individuals who really understand the issues and somebody that people can comfortably go to on a confidential basis, you know, for advice as to what to do about these type of situations, and really helps here to show the importance of role modelling and allyship too. Also, this champion or guardian could really feed into what you're doing in terms of measures to prevent sexual harassment, you know, when sort of looking at your risk assessment and what further actions you can be taking. Also, it's advisable to have a periodic review of any complaints, just to see if there are any patterns in terms of potentially who it's happening to, in terms of levels of employee, location perhaps, are there particular risk factors? And again, that can really help to feed into your risk assessment and decision as to what you can do about these issues as and when they do come up. So there are lots of things to do. And of course, here we're mainly thinking about how to avoid claims and compensation, but there is obviously a much wider benefit to preventing sexual harassment in the workplace, other than, of course, preventing claims and the sort of admin burden of dealing with claims and how that affects the workplace and financially, but also, of course, just making the workplace more comfortable, an attractive place to work. That's going to make staff more happy, and it's going to sort of happy staff are generally more productive if you're thinking about the bottom line too. Also, of course, to avoid reputational harm, we've all seen in the newspapers certain companies have had lots of stories about them, about sexual harassment issues happening at work and not enough being done over the years. So I think that's really one to think about there. And of course, in terms of creating sort of happy, stable workforce, it's also going to be helping your recruitment and retention of staff as well, which again is very important. And then finally, just to mention a note about the use of NDAs, so non-disclosure agreements, also known as secrecy clauses or gagging clauses. Now, often they're used, say, in a settlement agreement where there has been an instance of harassment, perhaps. You might be settling a claim, perhaps the employee and employer have decided to part ways, and it's common for the agreement to say that the employee won't talk about what's happened to anyone, bar some very minor exceptions. Now, this is, of course, a controversial area, and the worry is that you can be silencing people. And of course, in particular, in relation to the Me Too movement and the Harvey Weinstein cases, the issue there was that because the victims signed NDAs, they couldn't then take matters further at the time, they couldn't speak to each other. And therefore, in those type of cases, it can take a long time to realise that it's not just a one-off thing that's happening and it's a really big issue. So as I say, they are very controversial. And there is a continuing conversation about their use in particular in relation to sexual harassment. There is, though, two sides to this, and I would say they do have a place as well because they can encourage settlements. And of course, if an employer believes that an employee can take a settlement payment and then go into the newspapers and tell their stories, they're probably less likely to want to settle or to give such a a generous offer in terms of any financial amount. So I think there is definitely still a place for them to sort of try and encourage settlement, within reason. Currently, NDAs are allowed. There are limitations, though. You can't prevent anybody from reporting criminal behaviour, for example, and you also can't prevent them from being a whistleblower. Now, just in particular in relation to people in the university sector, just to note that there is some legislation coming in particular in relation to your sector under the Higher Education Freedom of Speech Act, which in January, the government confirmed that they will shortly be bringing into force some provisions, although there's no current timeframe for this, but it has said that universities would be prevented from entering into NDAs with not just staff, but students, members, visiting speakers in relation to sexual harassment, sexual misconduct, and other types of bullying as well. So that's something to look out for in that sector. And as I say, this is something that's been an ongoing conversation. So we may well find in future that restrictions are extended to other sectors or potentially across all workplace relationships as well. I think I'm just passing over to Matt.
Thanks, Amanda. So having covered duty to prevent sexual harassment and some potential implications of the Employment Rights Bill in relation to that duty, wanted to mention a couple of other things within the Employment Rights Bill that will have an impact. We don't know the precise timescale of when these will be introduced, similarly to a lot of the other provisions within the Employment Rights Bill. But just to mention these, so the first one is the requirement for large employers, which are defined as employers with more than 250 employees, to publish equality action plans. At the moment, those employers have an obligation to publish their gender pay gap. They are encouraged to publish or think about at least an action plan in relation to addressing that gender pay gap, but they're only encouraged to do that. That isn't mandatory. The new requirement will be for every 12 months when you publish your gender pay gap, you will also be required to explain what you are doing to try and address a gender pay gap if one has been identified. The reason for that is, having done some studies, the government found that at the moment only about 50% of people reporting their gender pay gap are also putting in place or publishing an action plan. The other thing that will be covered by those action plans is what employers are doing to support employees going through menopause. That was a specific manifesto promise by the Labour Party that they would introduce some protection and some guidance for employers in terms of supporting employees going through menopause. So those provisions will be put in place. When they will be, we don't know exactly, but there will be that extra reporting obligation on employers. The second reporting obligation, again, for the same category of large employers, those with 250 or more employees, is a requirement to report on the service providers they are using, the intention being to make employers accountable in some sense for gender pay gaps at their providers and to support their providers to improve gender equality. We see this in a number of different areas of law generally and regulation generally. We saw it within modern slavery, trying to make businesses accountable and effectively dripping down the obligations that the government wants to place on employers, businesses generally, by requiring employers who do use a lot of outsourced provision to cascade that down and to be responsible for what is happening within their supply chain. Obviously, we've got that in terms of modern slavery. The intention is also to have this in relation to gender pay gaps. There are some concerns around the extra regulatory burden placed on employers in the sense of this increased reporting obligations. Some of you may well have seen, some of you may be in the sector, the financial sector, where the FCA have stepped away from regulations that they were going to introduce, requiring employers to report on certain elements such as these on the basis that they said, well, if the government's going to regulate for it anyway, then it will come in due course. There's no point us overcomplicating things by regulating on these issues now. So there is some concern around this regulatory burden. And as you'll have seen in the obviously in the US, there's a big drive to sort of remove the regulatory burden of D&I from employers. There's no indication that that will be happening in terms of the UK government. In fact, it looks as though there'll be a greater regulatory burden in terms of these reporting mechanisms. Can you pop to the next slide, please, Tom? Okay. So moving on to legislation, we have this recent case that we've been waiting for a while, the Court of Appeal decision in Higgs and Farmers School. It is a case that is both from an employment lawyer's perspective interesting, and from employers' perspective, it is the sort of issue that we do see arising quite a lot within employers. And essentially, it covers a scenario where an employee publishes or makes comments that are consistent with their own strongly held religious or philosophical beliefs, and those statements conflict with and are offensive to another group with their own protected characteristics. So that can happen in a number of different ways. In this particular context, it related to an employee who worked in a pastoral capacity at a secondary school, and the school received a complaint from a parent about a Facebook post made by the individual in which she had reposted critical comments which related to teaching in schools about same-sex relationships, same-sex marriage, and gender being a matter of choice. So having received that complaint from the parent, the individual was suspended and eventually dismissed for gross misconduct. And the school took the view that the inflammatory language used in the posts, a parent had taken offence, and there was a potential risk of harm to the school's reputation. The individual brought claims for direct discrimination and harassment on ground of religion or belief, and the tribunal accepted that her beliefs in same-sex marriage and other elements of her faith amounted to a protected religious or philosophical belief within the protection provided by the Equality Act. So they were protected beliefs. The tribunal in first instance rejected the claims of direct discrimination or harassment on the basis that the provocative language used in her post might reasonably be perceived as holding homophobic or transphobic beliefs, which wouldn't qualify for protection under the Equality Act. The Employment Appeal Tribunal disagreed with that. They said they thought the tribunal had gone about it the wrong way, asked the wrong questions, and eventually the matter gets up to the Court of Appeal. And fundamentally, the issue is the extent to which an individual is protected for the way in which they express or they manifest their own religion or beliefs, where those beliefs are controversial or clash with the protected characteristics of others. And ultimately, in this case, the Court of Appeal found that the dismissal of this individual was an act of direct religious discrimination. She was being directly discriminated against for expressing her genuinely held religious beliefs. And the reason they found that is they said dismissing an employee merely because they've expressed a religious or other protected belief will constitute unlawful direct discrimination. However, if the dismissal is motivated not simply by the expression of the belief itself, but by something objectionable in the way in which it is expressed, then the dismissal can be lawful, but only if the employer shows that dismissal was a proportionate response to the objectionable way in which the views were expressed. And they looked at a number of factors here. One is they looked at the fact that the claimant had sort of effectively reposted messages that were quoted from other sources. Which they said was not as bad as her expressing her views in her own way. They looked at a number of issues on reputational damage and took into account that these were posted on the individual's sort of private Facebook page. There was a limited number of people who could see these views. They took into account the fact that the individual had never expressed any of these views in the context of her work. She hadn't been telling anyone in the staff room or any of the children or anything like that. She'd never expressed the views whilst at work. And in order to try and give some guidance to employers moving forward dealing with these difficult issues, they said that the employer, when they're determining the proportionality of disciplinary action in cases like this, needed to consider broadly three things. First of all, the subject matter, and expressing views about matters which have nothing to do with the employer's business will be less likely to damage its reputation. Now, here, of course, she was operating in a school. The school was providing this sort of education, so the subject matter was relevant. But other employees who in their private lives and their private social media express views on controversial topics that have nothing to do with what the business does, then that would be deemed to be less likely to damage the business's reputation. The second issue was the way in which the beliefs are expressed. And what the Court of Appeal said here was that the threshold of offensiveness should be set at a high level, and protection should not be lost, they said, simply because an employee expressed themselves intemperately. So there is a relatively high threshold on how forcefully you have to express your views for that to be deemed to be a significant risk of damage to your employer's reputation. Reading into that, what I read is, if someone is just engaging in a reasonable, well-worded, articulate debate on social media about these issues and expressing themselves in a reasonable manner, then that is less likely to be deemed to be something that would damage an employer's reputation. And the third factor was whether it was clear that the views expressed are personal to the employee, or whether they could be imputed to the employer. So in a case like this, was someone reading the post likely to believe that the employee was speaking on behalf of the school, or were they more likely to believe the individual was just expressing her personal views, which she was entitled to because they were protected religious views? And the view the Court of Appeal came to was, actually, anyone reasonably reading this would understand that she holds these views, but that's not what the school believes, because clearly the school's education programme was different. So it is a really difficult balancing act for employers, and it remains a difficult balancing act, but we at least have some guidelines now as to the way in which employers should approach these issues and determining the relevant disciplinary sanction, be that a warning or dismissal for expressing controversial but genuinely held religious or philosophical beliefs. In terms of what employers can do about it, one of the things which many employers will have in any event are social media policies. It will be difficult within those policies to prevent people in their private lives expressing their genuinely held religious beliefs, because one of the fundamental elements of this case is that we can't constrain freedom of speech. But things like making it clear that when people are operating on social media, they are very clear that they are doing so in a personal capacity and that there are no links to their employer, that those sorts of issues can help to protect these issues escalating and to protect employers dealing with these issues. Don't know whether that's judgment of the Court of Appeals going to be appealed. It was relatively recent. We may get some more guidelines in that area in the future, but that's what we've got at the moment. Next slide, please, Tom. So, wanted to cover what we call Section 19A claims. This is something that happened last year. We were expecting it to result in an increase in the number of indirect discrimination claims that we receive. Personally, I haven't seen a complete influx of them, but I think they are out there, and it is a risk that employers need to be aware of. The general principle of indirect discrimination claims that hopefully people will be familiar with is that there is a a neutral policy, so a provision, criterion, or practice, a neutral policy that isn't aimed at anyone in particular, but that has a disproportionately disadvantageous impact on a certain group with certain protected characteristics. Examples given are just to illustrate the point. So one is historically a very common example is a requirement to work full time. The suggestion is, although the statistics are changing slightly, if you insist on a job being done full time, that is more likely to disadvantage women because women are more likely to be the primary childcarer and not able to work full time. Requiring a new recruit to be a graduate tends to disadvantage older people because they were less likely to have gone to university. Or dress code requirements, which might be neutral, but which might impact on people with certain religious beliefs where they wear items of clothing or jewelry for religious reasons. So those are all things where you're not aiming the policy at anyone in particular, but it has a disadvantageous impact on people with a certain protected characteristic. And historically, only people with those protected characteristics could bring those claims. Section 19A changes that. And what Section 19A says is anyone can bring those claims if there is a protected group who are disadvantaged and if I suffer the same disadvantage. Based on the reason it was implemented was as a result of EU law and a European case in Bulgaria. So a woman lived in an area of a town that had a significant Roma population, but she wasn't of Roma origin. The authorities decided in this area to position electricity meters higher up because they had concerns about Roma families tampering with them. As a result of that, this lady couldn't see her meter and check her bills were correct, and she suspected they were not. So she brought a claim of indirect discrimination. And initially, the way that claim goes is, well, you can't bring the claim because whilst it may disadvantage people of Roma origin, you're not of Roma origin, so you can't bring the indirect discrimination claim. But the European Court of Justice said, no, that wasn't right. If there's a policy that disproportionately impacts portion of people with a protected characteristic, if you too have suffered have been placed at the same disadvantage, this lady was at the same disadvantage because she couldn't read her meter, then you can bring that indirect discrimination claim. So examples of that might be, now if we talk about full-time working or office working, for example, if an employer says everyone now needs to work full-time 9 to 5 in the office, as well as a woman with primary childcare responsibilities claiming indirect discrimination, it does potentially open up the avenue for a man with primary childcare responsibilities bringing that claim because he suffers the disadvantage. Or if you have a policy saying you need to be 6 foot tall to work here, as well as a woman being able to bring that claim for indirect discrimination because women are less likely to be 6 foot tall than men, a man who's under 6 foot tall could bring that claim because he suffers the same disadvantage. And so I don't think these are two nuanced points, because where I really think that employers need to be thinking about this is carrying out their equality impact assessments on particularly things like changing terms and conditions, because that may impact on different protected groups, for example, because of length of service, sometimes chasing benefits, etc. And historically, employers who might have changed something and said, well, we appreciate there's a potential risk of indirect discrimination claim from one small group, but we can live with that risk, or we can justify that. Just need to be careful that there isn't also, when they're carrying out their equality impact assessment, actually a much larger risk from another population without the protected characteristics, but who suffer the same disadvantage. Next slide, please. Tom. A very quick slide, just to let you know that with effect from last week, what we call the Vento bands for injury to feelings awards in discrimination claims have gone up. These are reviewed every year now. They didn't used to be. There was a long period when they first came in where it was fairly static. So if someone suffers discrimination in the course of employment and they are successful in their claim, they can be compensated both for financial losses and for injury to feelings. Injury to feelings are the tribunal has to first of all make an assessment as whether they fall in the lower band, the middle band, or the upper band. So the upper band is sustained campaigns of harassment. The lower band would be things like administrative decisions that are discriminatory but are not targeted as an individual, are not particularly emotive, might have had a financial consequence, but there's no significant injury to feelings. Those bands have gone up in the way set out in those slides, so discrimination becomes more expensive. Next slide, please, Tom. Okay, so we've got a lot of where we've got to, a bit of where we might be going with the Employment Rights Bill. I just wanted to have a few minutes to think about where we're going now, what the future holds in terms of diversity and inclusion. And a few things to mention here. So the first one, Amanda talked about the duty to prevent sexual harassment in the workplace. That's the only duty we have, or employers have at the moment. They don't have a positive duty to prevent racial harassment in the workplace or from third parties. They don't have a positive duty to protect employees from disability harassment in the workplace, or from gender reassignment harassment in the workplace, or from religious harassment in the workplace. Obviously, if that happens, it is unlawful and employers can be liable for it, but they don't have that positive duty to prevent it. And I know there are some groups suggesting that sexual harassment is not necessarily unique and that positive duties ought to be put in place in relation to either harassment generally or other forms of harassment. There's no indication of anything imminent on that. So from a legal perspective, there won't be, I don't think, a positive duty in the near future on that. But as employers, it is worth asking yourself when you are designing your training programs, are we just going to concentrate on sexual harassment, or are we also going to be training people with a view to preventing other forms of harassment, because you may take the view that that's the right thing to do. Similarly, on pay gaps, we only have at the moment the gender pay gap reporting obligation. There is a consultation ongoing about the Equality, Race and Disability Bill. The consultation finishes sometime in June, where the government proposes to implement pay gap reporting in relation to both ethnicity and disability. Neither of which is perhaps as straightforward as gender pay gap reporting, because there are some nuances there. So the first nuance we have is in relation to ethnicity, is it isn't just male or female. There are lots of different ethnicities within workplaces. How do you therefore report on your ethnicity pay gap? What the government have said in its proposal there, which is open for consultation, is that there should be a minimum of 10 employees in any ethnic group that's being analysed, and they acknowledge that this might involve grouping ethnic groups together to meet that threshold. And it also proposes an option for what they call binary classification. So where there's a small number of employees across different ethnic groups, it might be possible for them to report not in relation to each different ethnic group, but just saying, right, we've got two groups, we've got white British employees and ethnic minority employees, and we'll look at what the ethnicity pay gap is between those two different groups. For disability pay gap reporting, the government suggests a wholly binary approach. So rather, and they're relatively firmly of the view of this, that rather than saying, well, you gather data on the basis of different types of disability, it will simply be comparing the pay of disabled employees with non-disabled employees. Again, there are nuances and complexities with that, because generally speaking, no, there are some exceptions, but in terms of gender, we have a yes or no, and individuals can identify as one or the other. We know where we are. With disability, we will have some individuals with declared disabilities, other individuals with conditions that may or may not amount to disabilities, that may or may not be declared. So there are some nuances around that. I do expect this to come into force in some form. It will be similar, we think, to gender pay gap reporting in terms of the annual pay gap reporting. As I say, consultation runs till June. Let's imagine it won't be implemented before 2026. There are some employers who are being proactive about this now and identifying whether or not they do have ethnicity and disability pay gaps. But if they're not being proactive now, then certainly I would expect employers with 250 or more employees in the future will have to do some reporting on this. Just to flag that ACAS has relatively recently produced a useful guide on neurodiversity in the workplace. So things like understanding neurodiversity, talking about it in the workplace, raising the issues, discussing the issues, dealing with issues around performance, conduct, and capability. And there's also a module on making organisations more neuro-inclusive. A whole topic in its own right, really, but I flag that there so that those of you involved in that area, interested in that area, looking at guidance there, can use that ACAS guidance, which is quite useful. The other thing to mention, intersectionality. There's been a fair amount of discussion around this and a concern that the way in which regulations are framed at the moment, there is a risk that it is a bit too binary and that we're failing to look at issues of intersectionality. And what we mean by that is the way in which that people aren't simply one protected characteristic. So, for example, we see a number of cases, and one of the important cases in this area deals with the way in which older women in the media suffer and bring claims because they've suffered, not simply because of their age and not simply because of their gender, but because of a combination of the two. And we see it in other areas as well in terms of this intersectionality and the way in which there are certain groups with a combination of protected characteristics who are particularly poorly treated. And there's a bit of a concern that the government, with a lot of the regulation it's putting through, might be a bit behind the curve on that, and we might want to be thinking more, and certainly as employers and as society, more around issues of intersectionality. Final thing I wanted to mention in terms of the future, AI. We've done some sessions on this before, but again, just to flag to people who are looking at using AI within the HR context, so for example, recruitment or performance management, that there is an inherent risk with using AI of bias within algorithms. The ICO have produced some fairly good guidance on this. There is some guidance around for employers on procurement of AI and the importance of carrying out equality impact assessments, ensuring that suppliers of AI have carried out their equality impact assessment, understanding how where data is sourced, and checking that the data is not subject to algorithmic discriminatory bias. The reason why this is particularly important for employers, so for example, dealing in recruitment, one of the reasons for using AI in recruitment is because you've got large-scale recruitment exercises operated at scale, and AI offers huge efficiencies in terms of that exercise, which is potentially true. But because of the scale of that exercise, what that also means is if it happens that the algorithm has inherited bias from the data that it is using and is therefore, for example, excluding or discriminating against candidates with a particular characteristic, then that is also a mistake that is made at huge scale with multiple potential discrimination claims. So it's not a reason not to use it, but it is a reason really to be pushing suppliers on the protections they have in place to prevent discrimination. So that was what we wanted to cover. We've got a few minutes left for questions. Amanda, I don't know whether we've had any questions.
We have indeed. Okay. So the first question I think is about the reporting on service providers and their gender pay information, gap information. They've asked what type of service providers does this obligation relate to? Also suppliers of goods.
Yeah, well, I think we'd yet to see the detail on that, but yeah, in theory, I think it applies to. I'm not sure it will apply to someone who simply provides goods to you, but it will be someone who provides a service to you.
Mm-hmm. And then somebody else is up. Oh, sorry. Yeah, someone's also asked, does it only apply to service providers with more than 250 employees?
Oh, I don't know the answer to that question. So it'll be employers with more than 250 employees that have to report on it. I don't know the answer to that question, but I would imagine that if you've got a provider who only has 10 employees, requiring them to provide details about their gender pay gap probably isn't appropriate, but I don't know.
Yeah, exactly. And if the supplier is not going to be under the duty in the first place, it would seem odd that the other party's got to give information when they don't have to do it themselves, perhaps. But we shall see. Then we've got, scrolling for me. Okay, in terms of anonymous reporting for sexual harassment, so Fiona says we've been having a lot of debate internally about anonymous reporting for sexual harassment, and if we should encourage this, as it's then hard to follow up with the accused, as they won't have the context to respond. That is a really interesting point, and I completely agree with you. We don't want to be encouraging anonymous reporting at all. In your policies, we want to be encouraging people to come forward and to feel able to do that and comfortable and confident as to how you're going to deal with it. So I think the first position's always got to be you're encouraging them to come forward openly. However, I think it's more that we just suggest that there is a way to anonymously report just for those people that don't feel comfortable coming forward themselves, just so that it gives them that opportunity to still let you know what's happened, which is obviously better than them not telling you at all and then you're not finding out. So yeah, as I say, it's not that we're suggesting that you would encourage it. And of course, I appreciate in terms of then dealing with an anonymous complaint, it can be very difficult unless they're giving you names of other witnesses that you can speak to. And then, of course, you've got the worry of, is it a genuine concern? Is it a bit of a malicious complaint, perhaps? So it can be difficult to deal with. I agree with you, but I think it's always best to find out about the issues first and foremost. And then another question on the Higgs and Farmers case.
Yeah. So I'll take that one. So the question is, what are your thoughts on Higgs and Farmer in terms of the public sector context, i.e. employees are expected to foster good relations, advance equality, etc., and employees are also subject to the Nolan principles of public service. Was this taken account of at all in the judgment? I don't think it was. I can't remember reference to Nolan principles in the judgment. The public sector context is probably relevant when we talk about the three factors we had, and one of them was subject matter. And as I mentioned, in this case, the subject matter was relevant because it related to education and the school was an education establishment. So the subject matter of someone who works in the public sector, what they say, because they're an employee of a public sector organisation, if the public sector organisation is involved in those sorts of issues, which they are more likely to be, then that will be a relevant factor. So I think there is a relevance to the public sector context. But as far as I'm aware, there is nothing saying that, and I'd be surprised if there's anything saying that therefore means that if you operate in the public sector, you cannot express your personal religious views either in private with other individuals or on social media because of the freedom of speech angle. So I think there might be a slightly higher alert level, if you like, but I don't think it gets removed entirely. My thoughts on that.
Yeah, exactly. And I think what was interesting in that case as well is that the school didn't make a huge amount from what I read anyway about the fact that, you know, she was working in a school in pastoral care as well, and how the sort of, making of those views public could have affected that role. And maybe if they had made more of that, the case could have gone a different way, perhaps. So I think, you know, if and when these situations do come up, you've got to be thinking about not just that you might find somebody's opinions of, you know, not what you would agree with, say, maybe objectionable, but how it actually affects them in their role, which would depend upon what they're doing. And I think just one more, not so much a question, I think someone just put a comment really, in relation to pay gap reporting for ethnic minorities and disabilities. If an employer needs to be or have at least 250 employees to report on gender, given that genders are roughly 50-50, surely for 18% ethnic minority and similar for disability, employers should be much bigger before the reporting requirements kick in. I think really what they're saying though is that you're probably likely to have only a small number of people in each ethnic group, and then that does make reporting potentially a bit skewed. So of course we'll see what the regulations say when that comes in.
Yeah, we will do, and you are entitled to feed that back. There's a consultation process. The consultation process finishes on the 10th of June. So I know the comment says it's an event really, but that's exactly the feedback that ought to be provided. You have a voice in this, so I'd encourage that person to express that view in terms of the consultation.
Good point.
So I think that's all the questions. I think we're also pretty much bang on time. So thank you very much to everyone for attending. Have a good rest of the day. Thank you.
Thank you, everyone.